everyone. Welcome to tonight's talk. I'm Nikki from the Kellogg Hubbard Library, and we're pleased to be partnering with the League of Women Voters for this series. Before we get started, I'd like to let you know that this meeting is being recorded. Please remain muted throughout the presentation to ensure the best experience for all participants. If you have questions, please type them into the chat, and our moderator and speakers will address them. And now I'll hand it over to Anna from the League of Women Voters.
Good evening. My name is Anna Saxman, and I have the pleasure of introducing your moderator tonight, who is Lisa Scharf. Liz Scharf is the Director of Community Economic Development and Food Security at Capstone Community Action in Barrie, which offers some amazing services and programs to support the Vermonters with low income, many of whom are unhoused or face housing insecurity. Liz also, in her free time, has been the chair of the Middlesex Select Board, which she has served on for the last, I think, 11 years. So with that, take it away, Liz.
Hi, everybody. Welcome to tonight's panel. Thank you for that introduction, Anna. It's now my turn to introduce our panelists for this evening for the topic of the Garland versus Cargill Supreme Court case. So I would like to introduce Cabot Teachout. Cabot is an attorney in a private practice in Norwich, Vermont. He previously worked as a law clerk for Judge William Sessions of the Federal District Court of Vermont and Judge Peter Hall of the United States Court of Appeals for the Second Circuit. He also worked in the ABA Rule of Law Initiative in Kosovo. So welcome, Cabot. And I'm also pleased to introduce Billy Clark. Billy joined Giffords Law Center in 2022. As part of the litigation team, he develops affirmative litigation strategies to effectuate gun safety reforms and defends against constitutional challenges to a variety of gun safety policies. In addition, he consults with local governments and other organizations providing guidance on how to actualize gun safety policies, including by challenging legal impediments to those policies. Billy has a JD from Boston College Law School and a BA and master's from the University of Vermont. So welcome, Billy. So we're going to start out actually with Cabot Teachout. He's going to give us a history of gun regulation and laws in the United States and also directly in Vermont. And then after he does some talking about that, Billy's going to take over and tell us specifically about the Supreme Court case of Garland versus Cargill and how that relates to or how it might impact Vermonters. So welcome, Cabot. Why don't you take it away?
Thank you very much, Liz. To give some more background on my practice, I've been practicing law since 2010 in Vermont and New Hampshire in state and federal courts. I primarily practice criminal defense law, which means that I represent clients who are charged with a variety of offenses, including firearms cases. But I also represent witnesses and victims, including in family court cases and including victims of domestic violence. I regularly advise clients on state and federal gun laws and how they impact their rights to possess firearms. I'm going to provide a summary of some major federal gun laws and some major United States Supreme Court decisions regarding firearms, and then Billy's going to talk about Garland versus Cargill specifically. Lawyers have a tendency to speak in legalese or to skip over some simple concepts. So if there's anything that you want to know, please type it into the chat, and I invite anyone to interrupt me. I think if you type into the chat, Liz can raise that question, and I may not be looking at the screen. I'll try to, but feel free to ask questions. If you have a question, it's probably something that someone else is wondering about too. And real-time feedback is helpful for me to make sure that this is worthwhile to all of you. So don't feel shy about asking questions even while I'm speaking. I think the starting point is for any discussion about the law and firearms is the Second Amendment, but I have a spoiler alert, which Billy will tell you about later, which is that the Cargill decision actually isn't a Second Amendment case. And if you read the decision, the Second Amendment isn't mentioned anywhere in the case. It does, however, touch upon a very hot topic, which is firearms regulations. And so I'm going to start with the Second Amendment anyway, which provides that you all have heard this before, but the Second Amendment says, quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." And that's the Second Amendment to the U.S. Constitution, but the Vermont Constitution also has some firearms provisions. Article 9 talks about due process as it relates to firearms, but Chapter 1, Article 16 is kind of the corollary to the U.S. Second Amendment. And Chapter 1, Article 16 says, quote, "that the people have a right to bear arms for the defense of themselves and the state. And as standing armies in the time of peace are dangerous to liberty, they ought not to be kept up. And that the military should be kept under strict subordination to and governed by the civil power." We're not really going to get into either of those constitutional provisions in depth today, I don't expect. But I think it's important to remember that there are federal and Vermont state constitutions at play here. Now, I want to cover some of the major federal gun laws that I encounter in my practice and that are the subject of most federal criminal prosecutions and a lot of the public discourse around federal gun laws. The first law that I want to talk about is the National Firearms Act of 1934. And this was passed in response to a surge in gangland violence and crime that was rampant in the United States during Prohibition from 1920 to 1933. And it really was prompted by an attempted assassination of then President-elect FDR in 1933. It was introduced in May of 1934, and it passed less than 2 months later in June of 1934. And that law makes it illegal to possess machine guns, short-barreled rifles, short-barreled shotguns, silencers, and bombs, grenades, and other destructive devices. The laws also required that people who import firearms from other countries had to register them, and it established registration for these, the weapons that I just described, which are covered by the Act. I think it's kind of interesting that at the time that this was passed, I'm sorry, there was a exception. You could get permission from the federal government to possess these things, a machine gun, a short-barreled rifle, a grenade, or a bomb. And there was an application fee of $200. This is in 1934. And it's actually the exact, those exceptions and that fee is exactly the same. If you went to a gun store and you wanted to buy one of these things, you could, as long as you went through the process that was set forth in 1934, and it's still the same $200 fee. And you can get what's called an NFA, National Firearms Act, permit to acquire some of these weapons. But if you don't have the special permit to acquire these weapons, they're illegal to possess. Billy will talk more about this in depth later, but the machine gun under this National Firearms Act is defined as, quote, "any weapon which shoots, is designed to shoot, or can be readily restored to shoot, automatically more than one shot without manually reloading, by a single function of the trigger, end quote. One final point on the National Firearms Act, it's actually located in the U.S. tax code. It's under Chapter 26 of the U.S. Code. So violation of these laws is a crime, but it's a crime under the tax code, interestingly. The next major piece of gun legislation that the federal government passed was in 1968, and that's called the Gun Control Act. And this was passed in the wake of JFK's assassination in 1963. The rifle that was used to kill JFK was actually ordered by mail from a catalog. And there were gun control bills in Congress that were introduced in 1963 and 1965, which failed to pass because of opposition. Because I guess at that time people liked buying guns through mail order catalogs. But I think it's noteworthy that even at the time, the NRA vice president said of this legislation, quote, "We do not think that any sane American who calls himself an American can object to placing into this bill the instrument which killed the President of the United States." So this was actually something, a law that the NRA supported at the time. This is 1968, but it didn't pass at first. Some important things that eventually led to its passing were the University of Texas tower shooting in 1966. And then came the assassination of Martin Luther King in 1968, followed 2 months later by the assassination of RFK Sr. on June 5th in 1968. Ultimately, the Gun Control Act that passed was introduced 5 days after RFK's assassination, and it flew through the Senate. It was a little closer in the House, but it was signed by Lyndon Johnson in October of 1968, 4 months after it was first introduced. This law, the Gun Control Act of 1968, made it illegal for people who were under indictment or convicted of a felony, anyone who is a fugitive from justice, or anyone who's using marijuana from possessing a firearm. It also created a federal firearms license requiring that dealers of firearms must have a federal license in order to lawfully sell guns. It eventually made it illegal to sell firearms or to buy firearms by mail. And licensed dealers couldn't sell a rifle to anyone under 18 or a handgun to anyone under 21. It also established some restrictions for people from different states selling or acquiring guns from one another. And it required serial numbers on all guns produced by major gun manufacturers, not just the NFA firearms from 1964. All guns that are produced by manufacturers have to have a serial number. Also, in 1968, the NRA Vice President Franklin Orth wrote in the American Rifleman magazine that this measure, the Gun Control Act, as a whole appears to be one that the sportsmen of America can live with. And that was the major gun legislation in the United States that really carried through until 1993, which is the next series of laws that Congress passed, which placed further restrictions on the ability to possess and use firearms. And this one's called the Brady Act. And for those of you who may not recall, John Brady was the press secretary for President Ronald Reagan. And in March of 1981, Brady, Reagan, a Secret Service agent, and a DC police officer were shot during an assassination attempt by John Hinckley. John Brady was not killed, but he was paralyzed. He was shot in the head and he was paralyzed for the rest of his life. Now, Hinckley, the shooter, bought the revolver from a pawn shop, and during the purchase, he lied about where he lived, which was a violation of law. You may also know that Hinckley was obsessed with the movie Taxi Driver with Robert De Niro and um, Jane Fonda. Um, and he had actually been arrested just days before trying to board an airplane with, I think it was 3 guns and a bag full of ammunition. Um, he was, after being arrested for trying to board an airplane with 3 guns and ammunition, he was given a $50 fine and released. That was his sentence. That wasn't his bail, that was his sentence. He was released and he continued his obsession um, with trying to get close to President Carter and eventually President Reagan. He had previously been hospitalized. He had a criminal record, had lied on his application to purchase a firearm, and clearly had mental health issues. And so that led to those kind of series of conditions led to a package of gun legislation, which ultimately ended up being the Brady Act of 1993. Notably, there was a gap there, right, between 1981 when Hinckley tried to assassinate Reagan and 93 when the gun legislation passed. And what happened during that period of time? Well, first it was President Reagan, and then it was President Bush. And for political reasons, the Brady Act couldn't pass during the Republican president. But in January of 1993, Bill Clinton became president, and in February 1993, Chuck Schumer introduced the most recent version of the Brady Act, which ended up passing in November 1993, 9 months after it was first introduced. You notice a little bit of a pattern here. I didn't really realize it before I was preparing for this presentation, but it's just interesting to me that in 1934 it took 2 months for this major gun legislation to pass. In 1968, it took uh, well, took 4 months, and then the Brady Act took really 13 years or 12 years. But then once it was eventually introduced, it took 9 months. So the time that it takes to pass these important bills is becoming longer and longer. Um, Now, this Brady Act of 1993 established a lot of gun laws that some of you may just recognize and be familiar with. It established a national background check system for all purchases of firearms. It required a background check for any purchases of firearms from a gun dealer. It makes it illegal for someone for so previously it was illegal for someone who is a felony to possess a firearm. This made it illegal for gun dealers to sell to someone who is not permitted to have a firearm. It also made it illegal for someone who has been committed to a mental institution to possess a firearm. Someone who is an alien illegally or unlawfully in the United States. Someone who has been dishonorably discharged from the armed forces. Someone who has renounced their U.S. citizenship. Or, importantly, this is one of the most applicable provisions that I see in my day-to-day practice advising people who are charged with crimes. Someone who has a misdemeanor conviction for a crime of domestic violence, or someone who is subject to a domestic violence restraining order from an intimate partner or a family member. Um, so it also kind of closed the loop on some things that were left open from the 1968 bill, meaning that it made it illegal for people to possess firearms for under all of these conditions, and it also made it illegal for gun dealers to sell to any people who had any of these conditions. As a result, when you go and try and buy a gun anywhere in the country, you're subject to this background check process. I'm sorry, buy a gun from a gun dealer anywhere in the country. You are subject to a federal form which was established by this law, and you have to answer whether you are subject to any of these particular conditions before anyone will sell a gun to you. They will then call the FBI, the NICS system, to see if you have any of these, any felonies or misdemeanor convictions of domestic violence on your record or a restraining order, to see if you pass the federal background check before you get a gun given to you. Just very briefly, the Violence Against Women Act of 1934 didn't include any specific firearm provisions, but it did establish federal enforceability of state court restraining orders, and it created new criminal penalties for people who violated those restraining orders. That means that someone who is protected by a restraining order can go anywhere in the country, and it is enforceable under federal law. And finally, very briefly, there was the 1994 assault weapons ban that was passed by Congress under President Clinton. This had an automatic sunset provision. It lasted 10 years and it was never renewed. There have been a lot of efforts to renew it, but none have overcome the political opposition. That's an overview of the major federal gun legislation and gun laws that I wanted to provide to you. I'd also like to outline a few important firearms-related decisions from the United States Supreme Court. Unless there are any questions, I think I will continue.
I just had a brief question. Are you allowed to purchase a gun from like your neighbor, or is that not legal?
Not anymore, not in Vermont.
Okay.
And I will get to that, but Vermont closed the loophole and now requires a background check when you're purchasing from anyone who is not an immediate family member. So if you wanted to buy a gun from me, Liz, we would have to go to a gun store and have a federal firearms license dealer go through that process, which I described for you. So prior to 2008, there were not a lot of Second Amendment decisions from the United States Supreme Court. And in 2008, the U.S. Supreme Court decided Heller versus District of Columbia. And in that decision, the Supreme Court first said for the first time that the Second Amendment applies to individuals as opposed to just militias. This case struck down a broad ban against possession of handguns that was a District of Columbia law at the time. And that was actually, the District of Columbia is in kind of the special zone. So that was a federal law which prohibited the possession of handguns anywhere within the District of Columbia. The decision was significant for many reasons, but mostly because it was the first time that the Supreme Court truly endorsed the idea that there was a constitutional right for individuals to possess firearms for self-defense. Now, interestingly, Justice Scalia wrote the opinion, and he stated in his opinion, I should back up a little bit. Over the preceding decades, there had been some Second Amendment challenges to some of those other federal laws that I talked to you before, but they had almost universally been rejected. The idea being that it's totally okay under our Second Amendment, and it is consistent with the Second Amendment for the federal government to pass laws so that dangerous people don't have dangerous weapons. And Scalia went out of his way in this 2008 decision to say, this doesn't do anything to change our prior decisions. And one other thing that I will talk about briefly is that it's interesting to me how this case was engineered. Most cases that you see in criminal courts and most criminal decisions that you see are cases where someone has been arrested or charged with a crime. They assert some constitutional right or they make a constitutional argument, which they lose, and then they appeal to their Supreme Court, and the Supreme Court then decides the constitutional issue, and that's the new rule going forward. So they derive from, they're sourced from these individual cases, but the Heller decision was really the product of a case that was carefully engineered from the ground up. This was a case that was basically conceived by the Cato Institute, which is a conservative think tank, and it was modeled after Thurgood Marshall's strategy for ending school segregation. And what they did in this Heller case was someone at the Cato Institute handpicked a group of people to represent a diverse gender, race, economic background. They picked people with no criminal records whatsoever. They picked 3 men and 3 women, 4 white and 2 black people. All of them lived in DC. There was a federal employee, a mortgage broker, a police officer, a nurse, a lawyer, and one of the plaintiffs in that case was a gay person who had been assaulted uh, as a result of a hate crime for being gay, who came forward and said, had I been able to have a firearm to protect me, I could have defended myself. So these are very carefully picked plaintiffs in this case, and it was a test case to really test this District of Columbia law, which prohibited handguns. So instead of them being arrested and asserting their defenses at trial, this was really an offensive use of litigation to try and declare that this DC law was unconstitutional. And I just point this out because I think, as Billy will explain, this was a case where someone wasn't actually charged with a crime, but it was a preemptive strike based on a statute. And in Heller, it was a constitutional argument. Very briefly, and then I'll turn it over to Billy. The next significant case came in 2022. You may recall, just a few years ago, in which the U.S. Supreme Court in New York State Rifle and Pistol Association versus Bruin held that U.S. citizens have the right to carry firearms outside of their home for self-defense, and the government cannot arbitrarily prevent or interfere with that right. And that was based on, again, this was one of those strategic challenges under the selective use of plaintiffs or people bringing the lawsuits, where this basically this firearm organization outside of Albany handpicked a few people to represent a very sympathetic case for challenging New York's law. And New York's law said that if you wanted a concealed carry, or if you wanted to be able to carry a gun outside of your home, you had to go to your local police department, and the police department would decide whether you had a special need to use that gun outside of your home. And what the U.S. Supreme Court said was that that leaves too much discretion in the hands of local police department. If you are going to have a constitutional right, you can't give local police departments basically the say-all and end-all in an arbitrary vote over whether or not you have this constitutional right in public. And you can't use this authority arbitrarily. And this was also a watershed decision because it said that the test for determining whether a law was constitutional or not. Up until this point, everyone was like, well, what is the test? How do we know whether the Second Amendment allows this law or not? Up till then, no one was really sure what the test is. And this case set forth the test, which is that if there is a law that in some way restricts firearms, it is the government's burden to prove that the regulation is justified by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then can a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. What that means is the government has to show that we have always banned this type of possession or this type of use of a firearm. And that's very difficult. Obviously, there's technological advancements, as Billy will get to, and firearms are changing, and people's historical use is subject to constant evolution. And so after that decision, it was kind of fair game for a little while on what constituted permissible firearm restriction under the Second Amendment, because anyone could argue, well, we haven't had that law for our nation's whole history, so it's not consistent with our nation's historical regulation of firearms. That's exactly what this fellow Rahimi did. Rahimi was subject to a restraining order. This is a new case, and it's the last case I'll talk about. But Rahimi had a restraining order against him, and he possessed firearms. And he said, well, under this new law, under this new Second Amendment decision, I'm allowed to carry a firearm because there was no historical analog. There was no historical law that banned people like me who have restraining orders against them from possessing firearms. That just started in 1993. That's a brand new law, and we don't have a history of banning possession of firearms from people like me. And the Supreme Court kind of put a plug back on the bottle that they opened with the Bruin decision, and they said, you don't have to have exactly the same kind of law that existed for decades or for hundreds of years, just something that's analogous. And we have always said that dangerous people, that it's okay, it's consistent with the Second Amendment to prohibit dangerous people from possessing dangerous weapons. And by the way, Rahimi was the wrong person to make this argument because not only did he have a restraining order against him, but he was also charged with aggravated assault. And there were about 6 different incidents where he was charged and investigated for like firing his gun indiscriminately during raid road incidents and during arguments with friends in restaurants. And he was just not a very sympathetic person to bring this challenge to a gun law under the Second Amendment. That was an 8-1 decision. That means 8 justices voted to reject Rahimi's argument, and 1 justice voted to accept it. And that 1 justice was Clarence Thomas, and he is the one who wrote the decision that Billy Clark is going to talk about next. And with that, I will turn it over to Billy. Unless there's questions for me.
I think I don't see any in the chat, so why don't we move on to Billy, and then we can take questions from the audience. Thank you, Cabot, for that good historical reference for our next guest. Thank you, Billy.
Well, thank you, Liz, and thank you, Cabot, for that really insightful analysis. And thank you all for joining us, and thank you for the Legal Women Voters for hosting this. So we're going to dive in now to the Cargill decision, and I want to set the stage with, why the stakes were so high in this case. So, bump stocks were not too commonly known really until one tragic night on October 1st, 2017, when a gunman perched in a hotel window on the Las Vegas Strip opened fire on thousands of concert goers below. He used several legally purchased AR-15 style rifles, which were equipped with bump stocks. In 11 minutes, he wounded nearly 500 people and killed 60 people, and it remains the deadliest mass shooting in American history. Now, it's important, really, as Cabot was talking about the history of regulating machine guns, only fully automatic fire could inflict so many casualties so quickly. There were a number of witnesses, including police officers familiar with gunfire, who described hearing, automatic, full going automatic gunfire. There were more than 1,000 rounds fired by this one individual in 11 minutes. One witness, in recounting it to PBS years later, talked about it as, being chaotic and unreal, a human stampede with people bleeding and screaming and running. They didn't know who was alive, and, trying to go through the crowds. And I don't mean to, shock and awe, other than to say, you had the deadliest mass shooting in American history, and then you had a drive from the public to address this bump stock, this accessory to a firearm that really allowed this one individual to inflict mass chaos like this. So to go back to what Cabot was saying, there's uh, back in 1934 with the National Firearms Act, the NFA, that was when machine guns were first regulated at the federal level. Congress then twice sort of tweaked with the definition of a machine gun. Once in 1968 with the Gun Control Act, as Cabot was talking through, and then again in 1986. And it's really important to note that each time Congress worked on the machine gun definition, it was to broaden what constitutes a machine gun, because what had happened over time was that the firearms industry, responding or creating a demand for fully automatic gunfire among, untrained civilians, was finding ways to, create or mimic fully automatic gunfire through different mechanisms. And I guess I should step back just to, really differentiate. So semi-automatic gunfire, or non-fully automatic gunfire is when you pull the trigger on a gun and it then discharges. So that's, you have to engage the trigger in order for it to fire. Fully automatic gunfire is you pull back the trigger, hold it, and it just releases all the releases your full magazine, all the bullets that you have with you. And that's the sort of spraying of bullets that you see sometimes in movies and things. And to go back to Cabot's example, the Tommy gun from the 1930s, the gangster who's just unloading a full magazine, a big round magazine, and a large magazine of bullets. So that's the difference there between semi-automatic fire and fully automatic fire. Now, and unfortunately, the Cargill decision, and as we'll get into it, you can get lost in the details and lost in the intricacies of it and sort of lose sight of the purpose and drive of why Congress did these. It is a technical law. It's a technical federal definition, as it's provided under the law. At the same time, the whole point of this technical definition is to regulate and ban fully automatic gunfire. So again, to go back to what Cabot said, the specifics, the way that a machine gun is defined under federal law today is any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manually reloading by a single function of the trigger. And you can tell I'm emphasizing two parts there, the automatically part and the single function of the trigger part of the definition. And I emphasize those because that's what the court emphasizes in its decision. It looks to those two sets of terms to decide whether a bump stock falls within the definition of a machine gun. So, in response to the Las Vegas shooting, then President Trump in his first term, instructed the ATF to reconsider the definition of a machine to issue a decision about a rule about whether a bump stock qualifies as a machine gun. And ATF did issue a rule. It did engaged in findings. ATF is the Bureau of Alcohol, Tobacco, and Firearms. They're the federal agency that's charged with regulating firearms. Going back to what Cabot was talking about, they're the agency that was created by all those federal laws in the past. So they issued a rule called the bump stock rule that said bump stocks are machine guns. And there were several challenges brought to the rule. And those challenges universally failed. People said no. The courts that evaluated says no, those are not machine. They are machine guns. This ATF did not exceed Congress's power or intent. Congress wanted a broad definition of machine gun, and ATF has the power to say this is a machine gun. But there was then an outlier decision that arose. And as Cabot sort of explained with the Heller decision, we see in the Cargill decision a similar strategy of how to build a case that the folks who were bringing this challenge thought was likely to succeed. So Michael Cargill, who's a gun rights activist, he brought an affirmative lawsuit against the federal government, alleging that the bump stock rule was in excess of that a bump stock basically did not meet the federal definition of a machine gun, and that ATF didn't have the power to enact that rule, that somebody else would have to. Again, as Cabot said, this is not a Second Amendment decision. This is a somewhat wonky administrative law, is what it's called, decision about federal power and who has the power to decide something. It's still very important, but it is done at this, level of what does this federal statute mean? What does this federal law mean? So, the case goes up. The challenge is filed in the conservative Fifth Circuit. The Fifth Circuit Court of Appeals is the appeals court that out of Texas and covers some other areas in that area. They invalidate the bump stock rule. It's a sort of lengthy history that I won't get into all of, but the long and the short of it is the Fifth Circuit strikes down the bump stock rule. And so the case goes to the Supreme Court. Because now what you have is what's called a circuit split. Some parts of the country, really most parts of the country, most of the federal courts to look at it had said you can call a bump stock a machine gun. And then you have this outlier decision that says, no, you can't. So one of the main things the Supreme Court is supposed to do is resolve those sort of disputes between the federal courts. So the case goes up. So again, kind of going back to my introduction. So I work for the Giffords Law Center to Prevent Gun Violence. One of the things we do is we file amicus briefs in cases that we think are very important on gun violence prevention. So Second Amendment cases and these sort of administrative agency cases. So we filed an amicus brief in the case. And what an amicus brief is it's basically when an organization or an individual who has a perspective, expertise, gives its view on how the case should be decided, argues for how the case should be decided. And so we filed our amicus brief, and our amicus brief, really just focused on the fact that bump stocks, their whole purpose is to turn semi-automatic rifles into machine guns. That's what they are designed to do. That's the whole that's why you buy a bump stock. That's why the gun industry markets and sells bump stocks. In fact, as we showed in our amicus brief, gun manufacturers do not shy away from this fact. In fact, one manufacturer proudly stated, quote, bump fire stocks, which was their brand of it, bump fire stocks are the closest you can get to full auto and still be legal. Another manufacturer said that this was the standard battle style that you would want, so that you could have that fully automatic fire like you would have in, a military context. Again, there's whole debates of whether you would even want fully automatic fire unless your goal is to inflict mass harm, but that's beside the point. So, our brief really focused on that fact that that's what these are supposed to do. And Congress wanted ATF to have broad authority to address new developments in technology. They wanted ATF to be the agency in charge of making these decisions. And so there's it's absolutely within the authority that Congress gave ATF to say, yes, you can classify new technology as machine guns, and bump stocks fit within this. Unfortunately, the Supreme Court in Cargill came out the other way. So in a 6-3 decision, with Justice Thomas writing the majority opinion, the court held that bump stocks do not fall within the definition of machine gun at the federal level. And the way that it got into this was very hyper technical. And I'll just dive right in and can answer some questions after if anyone has it. Basically, the court went back to that definition that I read to you, to look at whether a bump stock allows a firearm to shoot automatically more than one shot by a single function of the trigger. And I guess, I can go into how sort of a bump stock works. The way that a bump stock works is the stock of the rifle goes up against your shoulder, and it sort of acts like a spring, bouncing the gun back and forth off your trigger finger. And so what that allows is that instead of having to manually pull your finger back each time, the movement of the stock back and forth sort of bounces against your trigger finger, and therefore you don't have to keep pulling back. It just the gun itself starts sort of going automatically. It just starts bouncing back and forth until your magazine is emptied. There are some skilled shooters who can bump fire without a bump stock. You can do it. It's not very accurate or safe. If you're, highly trained, you could. And there are some, skilled, marksmen, we talk about this in our brief, who can, over a great deal of training, pull their trigger finger back very quickly to start to get towards the rates you get with a bump stock. But you're not going to see that otherwise, among your average, individual, whatever level of experience, without being a specialized, trained, trick shooter. You're not going to be able to get that level unless you're using a bump stock. But again, to go into the definition, it's the court held that the single function of a trigger, that this was more than a single function because the trigger was being engaged each time the gun bounced off the still trigger finger. They said that it is not just a single function, like if you just pulled it all the way back and held it there. It's actually multiple functions because it's each time it bounces off the finger. Similarly, as it said, automatically. Automatically, in Justice Thomas's view, implied you push it once, it goes. This requires that bouncing, bumping to work. And I can get more into the weeds, but I don't want to bore this audience on the details of that aspect. But what I do want to flag is in the majority opinion, there's some really frustrating language from my perspective where Justice Thomas writes how nothing changes when a semi-automatic rifle is equipped with a bump stock. It merely reduces the amount of time. And in my view, it's how do you define nothing changes? I guess mechanically, nothing within the inner workings of the gun has changed, but in reality, in the way that the unfortunate concert goers in Las Vegas experience, you've turned semi-automatic fire into fully automatic fire, and so that's one of the most frustrating aspects of the majority opinion. And I'll, go quickly to the dissent on that before I come back to a concurring opinion that is important for our discussion. So it was, as I said, it was a 6-3 decision. The more liberal justices dissented, and I'll read a little bit from Justice Sotomayor's dissent because I think it really gets at this frustration, in particular when I'm trying to explain this to an audience of lay people of why this is being held this way. She wrote, "When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot. This is not a hard case." So, it really is getting at this. What is the purpose of a bump stock? It's to get towards fully automatic fire. It's to make it a machine gun. And yet, based on this, very hyper-technical reading of the statute, the majority came out another way. The last point I'll make about the majority opinion is, this case came at around the same time as this other decision called Loper-Bright, which I won't get into all the weeds of, but a lot of the question is, okay, who makes the determination? Who decides what's a machine gun and what's not? Congress passed the law. For a long time, we would allow executive agencies like ATF to come up with rules interpreting the law, and we would give what the courts would give what is called deference, Chevron deference back then, where it would say, okay, we trust agencies to use their expertise and knowledge to balance the different interests and being politically responsive in that they're a part of the executive and the president gets to appoint folks in that. So courts would defer to the determinations that agencies would make. Well, shortly after the Cargill decision came out, the court, in a separate case, that Loper-Bright, they got rid of deference to agencies entirely, Chevron deference. I don't need to go into that whole weeds, but again, a lot of this is about who makes the decision. And so now ATF doesn't really get to make the decision. The court is going to make this hyper-technical decision. It's going to review it and come to a different conclusion. And, you can argue whether that's the right way. I would argue that when you have multiple times Congress expanding the definition of machine gun, when you have Congress, looking to ATF to provide guidance on this, it does make sense to say that Congress wants ATF to be given some deference, to be allowed to respond to the technological developments and, address the new ways that are being cooked up to produce fully automatic fire. But sadly, that's not what the court said. The court struck down the bump stock rule. The The last thing I'll note about the decision itself before I get into some of the other, consequences and things. So there was a very short concurring opinion from Justice Alito, another, conservative member of the court. He joined with the majority, but he wanted to write separately to say, kind of getting at that question that I just raised, who decides, who makes these determinations. He said, look, Congress can act. Congress can, change the definition of a machine gun to explicitly include a bump stock. There's nothing in our opinion that prevents that. And what's implicit in that concurring opinion, which frankly was not explicitly clear, is that there's no Second Amendment right to have a bump stock, that it's not going to violate the Second Amendment if Congress comes in and says you can't have bump stocks. Again, this wasn't a Second Amendment case, but the fact that a conservative Supreme Court justice is saying Congress can pass a law to ban these implies that, a strong conservative voice on the court does not view it as a Second Amendment problem to ban bump stocks. So that is the decision. I'll just say very quickly, again, because it's not a Second Amendment case, there are many states that have banned bump stocks. Vermont is one of them. Vermont, after a close call in 2018, passed a series of gun laws we can talk more about in a minute. One of them was a bump stock ban. And there are many other states that do have bans on bump stocks still. And there is, still efforts to try to get Congress to, take up Justice Alito's call and, pass a bump stock ban. I don't, want to get into politics of that, but obviously that's a very complicated matter, as Cabot, sort of indicated, and how long it's taken to pass gun laws. It's not one that I'm particularly optimistic about at this moment. So that, I think, is the long and short of it, and happy to answer any questions.
I just have a question, and I'm not sure I'm going to be wording it properly, but it's made me think about. So from what I understand is that Congress had given the ATF the ability to make decisions about, as this, like you said, as the technology changes to say whether or not a bump stock was considered a machine gun. And since the Supreme Court then said, sorry, we think it's not, does that take away like sort of future authority of the ATF? Like how does that affect not just the ATF, but probably other, like, is this going to set precedent for other departments that are making, I don't know what you call it, a department, I guess, that have been given the authority to make rules? Is this going to potentially make that harder for ATF and even other departments?
No, it's an excellent question, and I mean the short answer is yes. It is going to make it harder. The way that it works, is that ATF interprets the federal law that's there, and so there have been other ATF rules, particularly after Congress passed in 2022 one of the first significant gun violence prevention laws since the Brady Bill. And that did include some things about the different, as Cabot was sort of talking about, the different background check requirements and things like that. The previous administration under President Biden had put forward several different, rules. The ATF agency had put forward different rules under that presidential administration. Those rules have been challenged in court, and certainly the Cargill decision is now precedent to say, no, you are not going to get deference. We are going to scrutinize this very carefully, and it's going to be difficult. It is going to, not only is it going to be difficult when these rules get challenged, but it does have a chilling effect on future agencies that may want to pass rules, because they're now going to say, well, here's an example of the Supreme Court. We thought it was pretty clear that bump stocks were machine guns, and yet it was held the other way. So will we even go ahead and make the rule? So yes, it will definitely have a chilling effect, not just on ATF, but agencies more generally. And, we can have a much bigger conversation about challenges with the administrative agencies, even in a post or in a pre-Doge and everything world. So, yeah.
So and there is a question that just came in, but I just, as a follow-up, does the Congress still has the authority to change the the law if they wanted to. They could say a bump stock is actually a machine gun. So it's not, so the Supreme Court ruling isn't the end all be all of bump stocks. If
No,
the
it's
Supreme Court were to take it up, if they wanted to take it up at some point in the future.
No, exactly.
Okay. I
Congress
didn't
could
understand
pass
that.
it and they could do it. Now, obviously, some folks may bring a challenge to say that it violates the Second Amendment to ban bump stocks, or any other myriad of challenges. Again, Justice Alito's concurrence is at least an indication that some of the conservative members of the court may disagree that it's a Second Amendment problem.
Okay. And then Marilyn is asking, I guess she's referring to the bump stock law. Can you explain challenges to the Vermont law?
Sure. So I'm aware of one challenge that was filed way back when, to the bump stock rule, to Vermont's bump stock law. That I believe was solely under Vermont's constitution. I think that case ended up not going forward. There have been challenges filed both back in 2018 and more recently to Vermont's large capacity magazine law, Vermont's waiting period law. The large capacity magazine case that was originally done at the Vermont level, at the within the Vermont court system, the state court system, because it was brought under Vermont's constitution, not under the Second Amendment. The Vermont Supreme Court, in a very important opinion back in 2020, held that it did not violate, that the large capacity magazine ban did not violate Vermont's constitution, and we can get into that absolutely. More recently, after this Bruin decision, which Cabot talked about, there was another challenge filed to Vermont's large capacity magazine law and to its waiting period law. And Judge Sessions upheld the law in the federal district court. He found that the law did not violate the Second Amendment. That is currently up on appeal in the Court of Appeals. But every Court of Appeals that is considered a large capacity magazine ban post Bruin has upheld the law. Most state courts have as well. We just had a great decision out of the Oregon Court of Appeals upholding Oregon's law. So generally, these laws are still being upheld.
I just want to confirm that I don't know if there's been a specific constitutional challenge to Vermont's bump stock ban, but to answer Marilyn's question, the U.S. Supreme Court decision doesn't affect it at all, just simply because Vermont's law, the U.S. Supreme Court decision was interpreting a federal ban, or rather was including bump stocks in a ban on machine guns. But Vermont has passed legislation for a separate law under Vermont state law saying that no one in the state of Vermont can have bump stocks, whether they were purchased before or after the ban went into effect. I had prepared kind of a basic summary of some of Vermont's more recent firearm legislation, and I'm happy to cover that. But Billy, I wanted to point out one part of the decision, playing the devil's advocate here, which is that prior to the Las Vegas shooting, and you may know more about the background than I do, but prior to the Las Vegas shooting, ATF on 10 separate occasions had said that no, we don't think the bump stock technology falls within this 1934 law, which prohibits possession of machine guns. And that after the Las Vegas shooting, the president asked the ATF to review that decision, and the ATF essentially changed their decision. And I'll just characterize it as a 180 just for purposes of making this an interesting conversation. But I think that there was some element of the decision which is like the Supreme Court saying, well, you can't just totally change your mind because something bad happened. The technology didn't change. The statute itself, the federal law itself did not change. It's just your administrative interpretation of how this technology fits within the federal law has changed, even though you've made the opposite decision 10 times before.
Was that political pressure, or was it like pressure from outside groups?
So a couple things. It's a great point, Cabot, and really appreciate you bringing it up. So the previous classifications that ATF had made had not been done through the formal rulemaking process. I don't want to get fully into the weeds with an audience like this, but suffice it to say, the previous determinations were done on more of an ad hoc basis of a company submits a product, a part of the agency looks at it and comes to a classification of whether or not. And so I agree that there does come a point of doing a complete about face. What does that mean for credibility and on interpretations? I do think, though, that we also should allow agencies to reconsider past decisions, especially when the past decisions were done on that more informal basis. And Liz, to go to your question, I mean, yes, it was, public outcry after the Las Vegas shooting that was motivating this. I mean, we were already seeing, more of these bump stock devices appearing, and then you had the largest mass shooting in American history occur. And so ATF, as a member of the executive branch, as a part of the politically accountable branches, responded to that by taking another look at this, and doing the more formal rulemaking process. And for those non-lawyers in the audience, the way that the rulemaking process goes is ATF did a formal notice that's printed out, and then different groups submit comments. Gun rights groups, gun violence prevention groups, individuals who may be affected by it. ATF goes through and addresses all those comments, and then revises its rule in response to the comments, and then comes out with the rule. So that would be sort of my argument back on that, is that even if, even considering those prior classifications, I still think that it makes sense for the politically accountable branch, like the executive branch, to be able to respond to that. Now, again, Justice Thomas would say, and Justice Alito certainly says in his concurring opinion, well, Congress is just as politically accountable, and they can, change it. Um, I my worry there is that, Congress already has acted by giving ATF this power. So that's, the challenge that arises there.
Cabot, I would be interested in hearing about Vermont laws. And I guess one question I have on a more federal level is that, we've seen these mass shootings and groups like Sandy Hook, group. Um, are they focused more on changing state laws because they can't sort of get into the, deeper into the federal laws, and so they find that they have more success on a statewide level? Um, because like I feel like, after some of these mass shootings, it's like, why haven't there been these major laws that have come up, preventing whatever type of firearm or somebody, owning the firearm. But maybe it is on a state level that it's happening.
I I think that's Billy's world more than my world, but I also I think it's a good introduction to what I wanted to just briefly, or what I can briefly touch on, which is just the most recent couple of Vermont laws regarding regulation of firearms. And I think most people would agree, whether you're gun control or gun rights, that in the past, Vermont has traditionally been viewed as relatively gun friendly. We historically have pretty low crime. We have relatively few large cities. And so I think there's a perception that we're somewhat immune to urban gun violence. Um, we're a rural state where hunting is an integral part of a lot of our community members' lives and heritage. And I think that people feel like small communities create more accountability and more safety. And so we haven't had a lot of gun laws. And we have fewer gun laws relatively than some of our neighbors like Massachusetts and New York. Um, in Vermont, you can have a loaded handgun in your car, but you can't have a loaded rifle in your car. There's a joke that that's because the legislature cares more about protecting white-tailed deer than it does its own citizens. Because they don't want people hunting animals from their cars. But um, there have been legislative efforts to pass gun laws for quite some time. Um, and they haven't really been successful because there wasn't enough political appetite for new gun laws. And that changed in early 2017 with two big events. The first was the school shooting in Parkland, Florida on February 14th. I'm sorry, 2018. Uh, on Valentine's Day 2018, which killed 17 people and injured 18 people. And that was done with an AR-15 with large capacity magazines. The shooter in that case, Nicholas Cruz, had mental health issues, and he had a history of joking about shooting up a school in the past. Following that, almost immediately after that, there was an incident in Fairhaven, Vermont, where a student was accused of planning a mass shooting, and he was arrested and charged with attempted murder and aggravated murder. In that particular case, a suspect had confided in a friend that in the past he had fantasized about shooting up a school or thought about it. And he had actually purchased a gun. It wasn't an AR-15, but he had purchased a gun. And when someone asked him about the Parkland shooting, he had endorsed or celebrated it. Based on that, the police interviewed him and arrested him. I want to recommend that people who want to learn more about that, there's an NPR, National Public Radio story about that, a New York Times story about that, and there's also some terrific local reporting covering that case, and it's worth a listen. I also want to add that the Vermont Supreme Court later found that there was insufficient evidence to charge the student with murder or attempted murder. But I think that at that point, the switch had been flipped, and there was immediate political response and an appetite in that moment for greater restrictions on possession of guns in Vermont and greater ability of law enforcement to respond when there's a case involving someone who is dangerous. And so April 2018, again, this is a quick turnaround. It's interesting to see how quickly some political responses are. So 2 months later, in April 2018, the Republican governor, Phil Scott, signed legislation which did several things. It passed a red flag law, which is known under our laws as an extreme risk protection order, and that allows a prosecutor, a local state's attorney, to file a petition asking a judge to prohibit someone from having firearms, even if no criminal charges or restraining orders are filed. These new laws required a universal background check for private gun purchases, so that while federal law requires that you pass a background check to buy from a dealer, nothing prior to 2018 in Vermont prohibited people from buying and selling to each other on a private basis. Now you have to go through that process. It also raised the age to buy a rifle from 18 to 21. Prior to that, an 18 or 19 or 20-year-old could purchase a rifle, including an AR or assault style rifle. The laws required removal of firearms from the home whenever anyone is arrested for domestic assault. And probably the most controversial is the restriction on large capacity magazines, which for a rifle is anything over 10 rounds, and for a pistol or revolver, it's anything over 15 rounds. And this, as Billy indicated, this specific provision has been challenged a couple times and has been upheld. And I think there may be an ongoing challenge to that under the new Bruin framework. And finally, that series of laws in 2018 banned bump stocks. And that still stands regardless of the Cargill decision. So I think that there is, certainly in Vermont, there was an immediate, more responsive reaction to these mass shooting events. And I think it's just incredibly difficult to do that on the national level. And the definition of machine gun that is discussed in the Cargill case is 91 years old, and Congress hasn't changed the definition of a machine gun. As Billy said, they gave some of that interpretation authority to the ATF, but Congress could probably in 91 years come up with a more modern uh, and technical definition of machine gun, and they haven't done it. So it's just really hard to pass federal gun laws.
Billy, do you have a minute just to respond to the question I had about, these advocacy groups and this whole state versus federal rules and do they sort of align with like red states and blue states as far as like gun, control measures and
Yeah, I
laws?
mean, so yes and no. I would say, at Giffords, I'll speak to what I do at Giffords Law Center, and Giffords Law Center, we're founded by Gabby Giffords and Mark Kelly, and those are two gun owners. They're still gun owners. We have our gun owners for safety group, and so we do look for opportunities to pass, the laws that we think are going to save lives. And that does not always follow a neat, red state, blue state division. So, at the federal level, we advocated strongly for the Bipartisan Safer Communities Act, which was passed in 2022 and did some really great things. Closed some loopholes that needed to be closed. Obviously, there's always more that can be done, but it really made some impactful changes, again, in response, sadly, to mass shootings in Uvalde and Buffalo. Across the country, there's lots of different places that we're advocating for. And it doesn't always go all on a red state, blue state line. One example I'll give is one of the new devices we're seeing a lot, not dissimilar to bump stocks, but it operates slightly differently, are what are called auto sears or Glock switches. What those are is it's a machine gun conversion device. It's a little thing you insert into a handgun, or it can be done in a rifle as well, but most commonly seen in a handgun, that converts it from semi-automatic fire to fully automatic fire. Actually, in the Cargill decision, they went out of their way to say that probably still does qualify as a machine gun. But a lot of states are looking to pass their own machine gun laws in light of the Cargill decision and some of the uncertainty at the federal level. So, for example, I think even Alabama is considering, a Glock switch auto sear bill because they've seen an uptick in mass shootings, unfortunately, involving this machine gun conversion device. So that's something that we're seeing, again, across the political spectrum. And that's something that we really value. We are still in communication with the federal and with Congress and looking for opportunities there. But you're right. I mean, it's a challenging landscape. At the same time, the gun violence prevention issue is very different than it was even 20 or 30 years ago. I mean, people want reasonable gun control. They want reasonable gun laws. They want common sense gun reform that's going to, you know, those measures like background checks, the things that we can agree to. There has been movement on that, and I think Vermont is a great example of that. These mass shootings becoming, part of our collective consciousness has really driven folks to want to have more of these laws in place.
Great, thank you. Are there any other questions from the audience? Either you could type them in the chat or just unmute yourself to ask a question. I don't see any. All righty. Well, I think this probably concludes our conversation this evening. This was super interesting for me, as I really don't know much about bump stocks or the gun laws. And I think you both did a fabulous job explaining it in layperson's terms, so that we could better understand the implications. And just the laws in our country and in Vermont. So thank you very much. I don't know if Kellogg Hubbard, are you going to pop back on for any announcement?
No, I mean, I'll pop back on, but thank you everybody for coming, and thank you for such an engaging and thoughtful discussion. So have a great night, everyone.
Thank you very much.
Thank you.
All of
Thank
you.
you,
That
Billy.
was
Thank you,
great.
Cabot. That was really great.
Thank you.
all.
Yes.